It's about politics, judicial decision-making, and the Supreme Court. How time flies. Because 7 years down the line, the entire country has had to think about whether there is a need for judicial reforms. Flowing 5 petitions to remove the Chief Justice, Gertrude Torkornoo, who has already been suspended by President John Mahama as part of the processes under Article 146 to probe issues against her. The Ghana Bar Association is against this, calling it unconstitutional. In Professor Atugube's submission, there is the need for public scrutiny of the judiciary if we were to sustain our democracy. Surveys by the CDD, among others, have made similar observations that there's a need to build confidence in the judiciary. But how far can you go to ensure that there is integrity of the judiciary and that integrity is intact? Separation of powers works, and checks and balances are seen crafted in Ghana's 1992 constitution are not seen as interferences. Hello, good evening, and welcome to Agenda. My name is Beatrice, and tonight we go into this conversation to try to bring a bit more clarity on what is too much, in this case politically, and what the law actually says. I do have on the panel with me lawyer Kojoga Adawudu. He's a private legal practitioner. He is also a member of the NDC Legal Committee. Good evening to you, sir. Thank you so much for joining us on Agenda.
It's a pleasure.
I have as well with me Gloria Oforibuedu. She is a lawyer and also managing partner at GOB Law Consult. Good evening to you, ma'am. Thank you as well for joining us.
Thank you, Beatrice.
And of course, we have as well Dr. Nyaho Tamaklo. He's founding member of the opposition NPP and a politician. He will be joining us very shortly as well. Remember that we're streaming live on 3FM 92.7. Send us your comment and we will read them back to you. I want to start with you, Madam Gloria Oforibuedu. The Ghana's constitution principally really makes it clear in its crafting that there is separation of powers and checks and balances. Would you say that at this juncture, the processes we have taken the Chief Justice through, we have lived up to, this principle, as it were?
No, it hasn't. The Chief Justice position should be with independence, dignity, impartiality, and should not have any form of executive or legislative control. Otherwise, we are in danger, because when the party changes, the government changes, parliament changes, at least we must have one institution which transcends partisan, changes. And that is the position of the Chief Justice and the judiciary.
That will be Article 127, I believe, 1271. But that statement you just made would also mean that you're completely rejecting the 146, which spells out the procedure by which a Chief Justice could be removed.
The 146 is just a technical provision, and I keep saying it. When I say it, some people accept it, others do find it ridiculous. But honestly, in all established democracies, the independence of the judiciary is guaranteed. Technically, there are some provisions, for example, in the U.S. Constitution, that a justice of the Supreme Court can't be impeached first by a majority of the House of Representatives, and then go for trial at the Senate. Okay, but this has never been used. It was only used once in 1806 when one Supreme Court justice was found, was impeached by the House of Representatives. But when he got to the Senate, after a trial, he was discharged. It's never been used. In the UK too, they have some provisions, technical provisions for removal of their, Supreme Court judge, but that has also never been used. So we also have that technical position in our constitution. But we know that it shouldn't be used, and it hasn't been used. and it should not be used.
But
otherwise, we'll have a place where the executive can impose on the judiciary, and we'll be in big trouble when that happens.
What would you say to people, and I'll come to you very shortly, Mr. Daudi, what would you say to people who say or counter what you're saying, that it's not the complete argument you're making, because when the then NPP wanted to remove Charlotte Osei, although the processes are not necessarily the same, you still went ahead and used the Constitution. So is that not double standard?
Was Charlotte Osei the Chief Justice?
I just
asking you that
by
question.
saying that it wasn't, they are not the same position.
So we can't compare that.
But again, the Constitution was used.
We can't compare Charlotte Osei to the Chief Justice.
Why not?
And we also do not know, we are not, discussing the facts of Charlotte Osei's removal vis-a-vis the facts of the Chief Justice. I wish we could, but I don't know if this forum will allow that.
And so the point you're making is to the question I asked earlier.
I'm saying that she was not the Chief Justice. Now we are talking about the Chief Justice.
I will come back to you, but I want
So let's not confuse the position and the facts.
We are not confusing the positions
because we don't even
have
the facts.
Yes, right? I'm just saying that the same way you're criticizing that this process, you're saying that Article 146 is technical and cannot be used in removing the Chief Justice.
I liken the Chief Justice to the President of the Republic, because the President of the Republic also has some technical provisions under Article 69 that he or she can be removed on 3 grounds, incompetence, inability to perform their duty based on incapacity of mind and body, and also misconduct. That's similar to the grounds for removal of the Chief Justice, but they are all technical, because I can't imagine how anybody would dream of removing the President of the Republic of Ghana for incompetence, misconduct, or inability to perform their duties in respect of their health and incapacity. It's never been done, and I hope it's not done.
You're claiming that the process to remove the current Chief Justice, you do not think that we are following the principles of separation of powers and checks and balances. How would you call it?
And independence of and impartiality of the judiciary. I see it as an anomaly. An anomaly, and that's all.
I'm coming to you, Mr. Daudi.
And carrying technicalities too far, which should not be done in a democracy.
Councillor Daudi, your thoughts?
Unless we want to subsume the authority of every institution of the state, every organ of the state under the executive. And that is not appropriate for a democracy, a multi-party democracy, which we are practicing now. Unless we want a one-party state.
So I just want Mr. Daudi to make his point, and I'll come back to you.
Thank you.
I think, good evening, Madam Gloria, but I think I utterly disagreed with my panelists, in the sense that it is not like there's a provision in the Constitution, that Article 146, and that provision, this is not the first time it's being used. So why is it that it should not be used this time? It is the Chief Justice now, Madam Chief Justice, her ladyship, Tokonu. This is the second time a petition has been made against her, right? I can tell you, within the Fourth Republic, Chief Justice Akwa went through the same process. It got to a point where the prima facie case, they realized that this cannot go anywhere. Chief Justice Wood went through the same process when Professor Mills was there. Chief Justice Sophia Akufu, there was a petition against her, but he never saw the daylight. Chief Justice Enim Yeboah, the same process. There was a petition against him. Chief Justice Tokonu, there was petition which was thrown away, and there is a petition now. The only difference we are seeing is that in this particular case, it has moved from the prima facie case where a committee has been established. Now, when the committee has been established, the committee now has to investigate and find out and give her the opportunity to be heard. So if we are saying that the provision should be there, it should just be kept there in the books, statute books, for that to gather dust. No. this is a provision that has given the procedure that when a judge of the superior court or a chairperson of a tribunal, if you read Article 146, the title says, removal of justices of the superior court and chairman of regional tribunal. So it is not like this process is a new thing that is being done. And it was during the case where Chief Justice Akwa, during the regime of President Kufuor, that Akwete Bright, Akwete, the revered lawyer, filed a petition. And that was when the court, in interpreting it, said that when you talk about Superior Court of Justice, the Chief Justice in the first place is also a Superior Court judge. So if the process has been made for all, then for the Chief Justice also, the process that has to be made in conjunction with the Council of State, they should be able to have a repeatable lawyer or an expert that would give assistance to the Council of State. So if it is now that they are saying that it should not be used or it is politically motivated, I disagree with them. The same process, 146, because Charlotte Osei also has her remuneration conditions to that of a Court of Appeal judge, and Madame Lamte, remember La Shraj, she was removed because there was a petition during the first term of His Excellency President Mahama.
So the point you're making is?
So what the point I'm making is that this is not the first time Article 146 is being used. And
for a Chief Justice?
For a Chief Justice, yes, it's been used for Chief Justice. The only thing is that it did not go beyond the prima facie case. And if there is no prima facie case, the process is truncated. So
which is now, what we saw when we saw former President Akufo-Addo was there, and there was that petition to remove him, and that was dismissed.
I would say that we should distinguish between petitions vis-a-vis processes. I think my learned colleague is mixing up petitions and processes. Yes, there have always been petitions. Why not? Everybody has the right to petition, okay? There have been several petitions against past Chief Justices, but there have not been a process to remove them. Never. It's never been done. This is the first time there's been an attempt to do that.
But if you look at, you're saying that we should be able to separate the petitions from the processes. But if you look at, again, I'm referring to Article 146, which you call...
I'm not saying whether, I'm saying that there are differences. There have always been petitions, but the process has never started.
And those who are criticizing whatever has transpired in the past is, we seem to, for the first time, have a government that wants to ensure that we exhaust the process that is in Article 146.
No. We rather appear to have a, well, will I call it a government? I would say it starts with the presidency, okay? Presidency that wants to impose its powers over a judiciary which should have been impartial, okay, independent, and also have some dignity.
Let me read it to you. Article 146.6, I believe, perhaps to 10. Hopefully we have time. It says, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. The committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President when the Chief Justice, whether the Chief Justice ought to be removed from office. 8 says, all proceedings under this article shall be held in camera, and the justice of chairman or chairman against whom the petition is made is entitled to be heard in his defense by himself or a lawyer. Now, when you check 10, it says, where a petition has been referred to a committee under this article, the President may in the case of the Chief Justice, acting in accordance with the advice of the Council of State by one signed by him, suspend the Chief Justice. It goes on to talk about, and even 11 says the President may at any time revoke a suspension under this article. So this article has spelled it out clearly. How then do you say that the President is imposing his
Well,
executive powers on the
likewise,
judiciary?
Article 69 provides that the President shall be removed from office if he is found in accordance with the provisions of this article to have acted in willful violation of the oath of allegiance and the presidential oath set out in the second schedule, or in willful violation of any other provision of this Constitution, or B, to have conducted himself in a manner which brings or is likely to bring the high office of President into disrepute, ridicule, or contempt, or prejudicial or inimical to the economy or the security of the state, or C, to be incapable of performing the functions of his office by reason of infirmity of body or mind. The provisions are there. Have we ever used them?
But what is the problem? What is your problem with the President or the government deciding to go through it? At the end of the day,
no, I'm asking
we've heard assurances from, for instance, government spokesperson Phyllis Kwachofosu, and even the President himself saying that we are following the process, we're going to be sure that we are fair, and at the end of the day, if there's nothing that we find against you, well, the law would take its right course. So why are you against the fact that the President is going through the process?
We are talking Constitution. So I'm saying that those provisions, similar to Article 69, are just technicalities. We had a president in the US who was believed to have fainted a few times, but nobody even dreamt of removing him. Likewise, we had a president who in Ghana who even died in office from natural causes, okay? But we never dreamt that we will use this Article 69 on, being incapable of performing the functions of his office by reason of infirmity of body or mind to remove him. We never dreamt of that. We can't do that. This is our democracy. Technicalities should not be used to usurp or distort, okay? To usurp or distort the sustainability of our democracy, especially a baby democracy as ours, which is only 33 years old.
You're saying this is a distortion of our democracy?
Of course, if you decide to remove a president, isn't that a distortion? Well, if we are to remove the president for, what do you call it, even acting inimical to the economy or the economy, for example, then every budget reading will remove the president.
Well, you're saying that if you decide, so the understanding...
So I'm just saying that these are just technical provisions.
Just a second.
We never do that.
The understanding I'm getting is that the president has already decided that the Chief Justice will be removed. Because you said if you decide. But as far as we
I'm saying that if we are citizens of Ghana, anyone can petition, remember, anybody can petition. But if we decide, or if someone petitions that we should remove a president for, acting inimical to the economy of Ghana, that's so ridiculous. Then every budget reading will remove the president. So these are just technicalities in our Constitution. But for the sustainability of our democracy, just as we will not, dream of removing a president on these three grounds, likewise, we should not dream or even fantasize of removing a Chief Justice. So just for the sustainability of our democracy. That is my reading.
Yes, but
that is the practice.
I totally disagree.
Well, you are free to disagree.
Yes, because in the Constitution,
the beauty of democracy.
This is the supreme law that we ourselves have enacted and agreed as citizens. And we are saying that, so provisions that we have made, arrangements to guide us, we say, because this provision, we think that when we touch it, it will irk, people will be angry, some will not be happy, so we should leave the provisions. No! When there is a provision, there is also a procedure for the removal of the president. And it says that if 2/3 or majority of parliamentarians petition, it goes to the Speaker. The Speaker gives it to the Chief Justice. That is the process. And nobody has petitioned, or parliamentarians has petitioned. We had an example in the past government. Have there been any censure where they have petitioned for removal of a minister? It has never been happened, but it happened. When Ken Oforiatta, they tried that they were going to remove him. So if you say there are provisions,
please, the minister, don't confuse the minister with the president.
You are saying that there are some provisions that we should not touch those provisions. It should be there. They should beautify
the president
our constitution, and that we beautify our constitution and say the provisions. That is why the Supreme Court has
Why are you confusing the minister with the president? Please, the legislature, the what do you call it, MPs, the legislature, the MPs, the Speaker of Parliament, they have different provisions. Yes. It talks of vacation of seats. I'm talking of the president, who has similar provisions for removal, similar to the Chief Justice.
Yes, and I'm saying that. So you say we should not touch those provisions.
Yes.
And I'm saying that why should we? So we should just beautify our constitution. It sits in our constitution, and we say this provision. That is why the Supreme Court has been given that power to interpret every provision in the constitution which we have agreed. That as people, this is the constitution that should. So if you say it should be there, it should not be used.
Let him make his point.
Yes, it should not be used. I think that people are learning, law students are learning, and we are saying that some part of the provision cannot be interpreted. Some part of the provision cannot be worked, because if it is worked, it will affect democracy. I think that the reverse is that once every provision within this constitution is looked at, it strengthens and deepens the democracy. We need to have that courage. I think that is where people are saying that, look, President Mahama, you've had the courage to see with the Council of State, to see that, look, let's go beyond. Let's give the Chief Justice an opportunity to be heard. And when she's heard, and she's found that she's not culpable, the recommendation will be for her to continue. That is one of the reasons why the framers of the Constitution says that the proceeding should be in camera. The reason why it should be in camera is that a judge is not like the politician who will have people or his party to speak for him. So if a judge is scandalized by baseless allegations, things that are not founded are unfounded, and once it is in the public domain, and at the end of the day that judge has been found innocent and even brought back, what have you done to the judge? You have destroyed the image of the judge. You have destroyed him as a person. That is the reason why it says that that damage is irreparable. You cannot do it. So even in the Ajay case, when Chief Justice Akwa was supposed to go and face the committee, the court said that no, one of the good reasons is that the process should be in camera, and the judge will have an expert and a lawyer of his or her own choice to do it. So if it is about this provision, we are behaving as if President Mahama just this 3 months imported or wrote Article 146 and planted it in our constitution. No, it's always been there. Let's give every provision. If we think that what the president is doing is unconstitutional, please, you have opportunity to go to court and say, look, it is unconstitutional. But if nobody has been able, since this matter has come, to tell the public, or for me to hear, that the president breached Article 146 by doing A, B, C, D. Nobody has ever said it. It is all about emotions. Why are we doing this? Why are we tinkling with the provision? And because the provision, we think that there are some places that it is defective. If you think that it is defective, once the committee sits down, you see, there are eminent people on this committee, and they sit down. Don't think that this committee, they have worked several years, and they will just go there and lose their integrity and lose all that they have, right, worked for, will lose it and say that because it is politically mixed with law, let's play politics, and our integrity. Posterity will judge them. And look, we have 2 justices. That is the Chief Justice colleagues that they work together. those two justices understand the workings of the law, understand what happens, I can tell you on authority that when it comes to Chief Justice Tokon with her law, her competence, I will stand up for her. But you see, the same law says that if you are the head of the judiciary administratively and you've done things administratively which ought not to be done, right? Can we say that maybe the malfeasance things that has gone on administratively cannot be looked into? Ajechu said that no, it can be done. So if there is an allegation of bribe against any of the judges, like we saw in the Anas case, what happened? It was not about that they misconducted themselves by law, but maybe administratively they have done something. So that is why the opportunity is being given to the person. The person will go and defend. The mere fact even that she asks that give me opportunity to respond, it means that some issues have been raised. If illegal issues or some issues were not raised, I would have said that I've treated it with contempt that look, the committee, I think what issues they are raising does not matter. But issues were raised, she responded to the issues. Once the issues have been responded, all this will be put before the committee. And once the committee sits, the committee will look at it. They should tell us how the president has breached the Constitution, Article 146. Nobody is telling us that. Not even GBA is telling us that you breached, you didn't use this discretion properly, you've not done it. We are not being told that. All we are being told is that, oh, we should not go, we should withdraw it, so, and there's no way, right? Within the procedure, that what we are saying, that the president is doing something wrong. No.
So this is what the Ghana Bar Association in that resolution said, revocation, and I'll come back to you very shortly. Revocation of suspension. The Ghana Bar Association calls for the immediate revocation of the suspension of the Chief Justice as it considers the suspension to be unconstitutional, considering the fact that the President, who is not a judge or judicial officer, exercises discretion to suspend the Chief Justice under Article 14610 of the 1992 Constitution in the absence of a published constitutional instrument, statutory instrument or regulations governing the exercise of his said discretion as required by Article 296 of the 1992 Constitution. That's the point you have a problem with, that they didn't provide any evidence that indeed the President is at fault.
No, they didn't do anything. And how could they, within 146, Article 146 or 296 that they are bringing in, right? You think when the Supreme Court was interpreting the same 146 in RJ2, they never adverted their mind to the whole provisions in the Constitution? They did. So what are they saying that he didn't do well, that he should reverse? And
I want to come to you, Madam Glory. Yes. I know you want to respond, but the question I want to ask you, I know that I've tried to ask you about certain processes that were done which are also constitutionally spelled out, like the removal of the Electoral Commission boss and a few others. You say you don't want to touch those, but are you saying...
I never said that.
You say you don't have the facts.
I asked you two questions. The fact is the, what do you call it? The EC, the Chief Justice.
I think I prefaced,
and were the facts similar? Yeah, and since we don't have it, I will humbly say that let's not go there. We can have another day where we'll come and look at the facts.
But that's another constitutional provision. Which
we can, because I don't think we have enough time. Let's focus on the Chief Justice.
Question I wanted
because
to ask
he said a lot. Okay, you can ask me the question.
It's based on your argument, are you
arguments? I'm not
based on your submission. Are you saying that the Chief Justice is above the law?
I'm simply saying, now, just a point of correction. This is nothing to do with emotions or partisanship or biases or prejudices. I'm looking at the Constitution and I'm saying a Constitution is a living being, okay? is a living being. The fact that it's the constitution doesn't mean that we should constitution then it's stagnant. We look at circumstances, we look at situations, we look at practices, we look at technicalities to implement it. Here we are looking at Article 146 Clause 8, which says all proceedings under this article shall be held in camera. We are now in a modern age with a social media boom where the petitions against the Chief Justice were leaked to the public and it's everywhere on social media.
But you know that
I haven't finished. Let me land.
Okay.
Now we also have the responses on social media. Are you telling us that with this information boom, we can say that, oh, because you know, it was provided that it should be in camera. Now that is being on social media, and now that we have it on what do you call Instagram, X, that's now X, and then Facebook and what have you, everything should be in camera. Immediately you realize that even though in camera is stated in our constitution, because our constitution is living being, now the camera provision is outmoded and archaic, and so we cannot, after all this information, go and hold something in camera.
I will come back
that
to
is point number one. Point number two, even the provision for regional tribunals under Article 142 are no longer in practice.
Okay, so
there are provisions there, but we don't practice it.
If I may use your same law, that we are not talking
I'm not
about
my same law. The constitution
the
as a living being.
Madam,
the regional tribunals are in the constitution,
if I can use
but we don't have
the
them.
same submission that you've made, that we are not talking about other areas. Right now we're talking about the CJ, so perhaps we should stick with that. But you haven't answered the question as to whether or not, based on your earlier submission, the Chief Justice is above the law. Is she above the law?
There's something called rule of law. The rule of law, you know, the rule of law came about it from our Commonwealth, the initial, you know, UK, where we had different lords and royalties who at that time were influencing the law or deciding the law. But then in 1211, if we can calculate 1211, how many years ago? 1211 years ago, the British, you know, they don't have a written constitution. Yeah. Okay, the Magna Carta came out. That's the charter of the Great Charter. That in Latin is Magna Carta. The Great Charter said that henceforth the royals, the kings, and all that should be subjected to the rule of law. So it's no longer the kings who will decide the fate of individuals or individual rights, but rather the Great Charter, the rule of law. So nobody is above the law, including the Chief Justice. There's the rule of law.
Excellent.
And using the Constitution is one of the rules of law.
Excellent.
But the Constitution is also a living being.
So can I ask my, you've answered the question you've answered the question that she's not above the law.
Yes, nobody. The rule of the president is not above the law.
Can I ask my question? She's not above the law. The president is not above the law. Nobody is above the law.
No.
So what is wrong if you are not above the law and people feel that there is something against you which needs to be investigated, and the government in power decides that, okay, we see a prima facie case, let's go through the process. If at the end of the process we don't see anything wrong, we'll leave it as it is. If there's something wrong, we'll follow through with the Constitution. What is wrong with going through the process when you're telling us that nobody is above the law?
Nobody is above the law. Nobody is above the Constitution, okay, which is the basic law of the land. But nevertheless, in a multi-party democracy, let me emphasize, multi-party democracy, not a one-party state, not a dictatorship. The Constitution is a living being. So it's not every provision in the Constitution that technically is implemented. For example, the regional tribunals. We had the regional tribunals some time ago. It's firmly in the Constitution under Article 142. And it says there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. And so a regional tribunal shall consist of the Chief Justice, one chairman, and such members who may or may not be lawyers. it came into a time in our political history that the regional tribunals were used to abuse and infringe upon a lot of individual rights, even to the point of declaring some of them to death by firing squad in our revolutionary history. So we decided that we will not use the regional tribunals. So it's captured there vividly, verbatim, but it's not being implemented for the sake of sustaining our multi-party democracy. So please, I'm just telling you that we have some provisions, but when we look at the Constitution as a living being, we don't just run and say, hey, but the regional tribunal, everybody, even if you are not a lawyer, come and judge people, and then you listen to one side, and then you decide to send them to firing squad.
And I believe that's one thing that the current Attorney General, Dominic Ayine, has already expressed some interest around that. Perhaps when we come back, we'll touch briefly on that and also go into really the way forward, whether after all is said and done, there's a need for constitutional reforms, or like people feel, perhaps politics is taking the lead in the kind of argument we are making as regards whether or not there's a need to go through the path we're going on now. Just stay with us. And you're still here on Agenda on TV3 with me, Beatrice. And tonight we're looking at this brouhaha surrounding the process to remove the Chief Justice, Gertrude Torkornoo. As you're aware, she's already on suspension. And we are having a conversation around the constitutional provisions. If you're just joining us, really, we've had Madam Gloria Foribwedu, who is a lawyer, Victor Kojo Daudu as well. He's also a private legal practitioner, really sharing their thoughts on whether or not there's a need to continue with this process. And before we went on that break, I was telling you that the regional tribunals we talked about, you mentioned earlier, that is something that we don't practice. I'm sure you're aware that Dominic Ayine, the Attorney General, during his vetting, he indicated that it was the public tribunals were something that he was considering re-establishing. And so, well, that's something that perhaps is in the offing in terms the petition's filing, and a member publicly described the petition as quote-unquote stupidity. This taints the consultative process and raises doubts about its impartiality, which is essential under Article 146. If you read the entire submission he's made, he's saying that at least this time around, there's an opportunity to test the Constitution. There are people who argue that the only way you can grow your democracy is when there are tests and you are able to prove that this is right or wrong.
You know, talking of the Council of States, okay, as a Ghanaian, you know, beyond partisan lines, I think we should be blamed for always using the Council of States, mostly I would say, as a place for retired politicians or politicians who we believe had, you know, earned their due, and then we put them on the party that comes into power will find a way of putting their partisan older people on the Council of State.
So you admit that the Council of State members are full of politicians?
It's always been like that. Every party since we had our constitutional democracy, be the NDC or the MPP, has always loaded the Council of State with, you know, older politicians who definitely will have some partisan affiliation. I'll humbly plead with the Constitution Review Committee to have a real look at the Council of State. If it's possible to have impartial, non-partisan, you know, nominees and appointees to the Council of State, that will help us. So please, let me land. You are young, me, I've grown. No, I'm talking for you, for your future. Now, based on that, we can have an impartial and independent-minded Council of State in the future for the sustainability of our democracy.
So based on what you said...
That's my humble plea to the CRC.
Based on what you said, would you say that it is fair that those who argue that perhaps the first petition was dismissed because of political reasons, they were right? Because then
I will
the
just say that the whole
if I may land as well, the Council of State advised the president, based on what the president said, there's no case in this. And so the same way that we're having the current Council of State advising the president to go ahead, perhaps that's what transpires.
I'm saying that the Council of State, irrespective of which government is voted by the ordinary citizens into power to serve us, not to torment and load over us, but to serve us, irrespective of whichever government we vote for, should not be partisan. And so the Constitutional Review Committee, right, should have a look at the membership, or a real look at the membership of the Council of States.
Let me ask you what you think about this proposal from Madam Ofoibuedu.
And then secondly, the prima facie case too. We will also appreciate knowing more about that, what went into it, what were the considerations. That will also help for the, you know, as for the sustainability of our baby democracy.
So I want to ask you your thoughts. I'm going to ask you two questions in one. We're almost running out of time. What you think about this proposal by Madam Gloria Ofoibuedu, and moving
recommendation, to the Constitution Review.
And moving beyond the Council of State, the overall recommendation, for instance, by the previous Constitutional Review Commission in 2011 that said that in order to clear this political perception about judges and just within the judiciary, let's actually let the Judicial Council be the ones, or members of the Judicial Council appointing justices or judges to the Supreme Court and other courts. So I'm asking you two questions in one.
Let me start with the last one, then I'll come. If we are talking about the Judicial Council, who appoints the people to Judicial Council? And two, because there are institutional representation to the Judicial Council, and government also appoints people to Judicial Council. We are in this country, and the Supreme Court has, in the case of the GBA versus the Attorney General, right? The court said that anything the Judicial Council says as an advice, you are not bound by it. Are you getting? So is the Chief Justice going to be bound by it? They can give the advice to President, and President will not be bound by it. So because it's an advice. But you see, when it comes to the process before judges will be appointed, there's a process that it goes through. It's not just the background check and the rest. So, yes, if we want to have an independent body, which that the judges appointed or judge will go through our constitutional review, we can go through it. Now, every time we talk about the Council of State, if you look at the whole structure, the framers of the Constitution looked at, it is not about being tired brains or retired brains that are there.
Oh, don't use those words.
No, that old politicians who are occupying there. No. In this present Council of State, we have a very young man. He's
I
not
think
even
the point
30.
she's making is that you have politicians on the Council of State.
But also, you have a former Chief Justice, a former IGP, a former CDS. They are public servants who have served this nation because we want to tap their rich knowledge.
Mr. Dauda, are you dismissing the fact that wait. Members who are politically affiliated on the Council of State?
Yes, who has made it so? Because when we are to elect, every region has to elect a representative. And it is the district assemblies that forms a college, right? What has made it to become political when it is being elected? And in the first place, remember, none of those people stands on the ticket of a party.
So you are saying that when they are political?
It is when the election, who becomes the favorite? Who is the favorite, or who they think that sympathize? Because the election is done by the assembly.
You're not
and at the time, I'm coming. At the time the assembly is going to elect, the people there feel that who represents their interest, who aligns with them, who thinks like the way they think, and that is the person they vote. No political party sponsors any candidate to them. So if you say it is a place where all old politicians are put, I beg to differ that there are people there, and you see, the people over there, most of them, they have worked, they have seen what is life. It is not about young people coming to influence them in what they do.
So what you're saying is that you admit there are politicians on the Council of State, but not all of them have political affiliations. Is that the argument you're making?
Exactly. Everywhere in our fabrics of society, you find politics has permeated society.
She's recommending, Madam Gloria for everybody is recommending that we're able to change that so we deal with this problem. Do you think that's possible?
I think that the Constitutional Review Committee is working, and we can put a memoranda before them and that, look, we think that this thing is defective. Within the Council of State, the composition, something has to be done by it. Why not? And once it's put before the populace and the citizens of Ghana, they will go to that.
Yeah, because we under Article 89 on the Council of State.
If you can be very brief, because I need to read some comments and there are some questions for you as well.
We have 11 other members appointed by the President. Yes. So if we can remove that, so that there will be 11 other members, alternatively appointed.
So the number of you who have sent in your comments, I'll try and read some of them, but there's one coming from Thomas Anaba, who is the Member of Parliament for Garu, I believe, and a member of the Health Committee. He said, good evening, Beatrice. Tell Madam Gloria Oforiboadu on your show that there are 2 Supreme Court justices in the committee set up to investigate the CJ. Is she telling us that those 2 justices in the committee do not know the President is usurping the powers of the CJ? She should give us a break. The CJ is not above the law. And so that's
no, I never said the CJ is above the law. No, we are all under the rule of law. So it shouldn't be biased and send biased comments.
Also, there's Nisai from Facebook. He's telling us, if you're a constitutional lawyer and you're spewing, okay, I'm sorry. Then he said, then I'm better off training. Okay, I'm sorry.
Don't worry,
I'm sorry, I'm not able to finish reading your statement.
But what's his background anyway? He needs some education on how to express himself.
Okay, so the CJ, somebody, Abu Lawe says the CJ will go and, okay, So he is obviously for the process that is currently ongoing against the Chief Justice or regarding the case against her. William Jikunu says this constitution review will never go through the referendum, or else they will use the constitution to trap poor people so that the rich can enjoy. See today how some, okay, he's not too happy with lawyers and using some words. And why the women don't respond to your, okay, so somebody that is okay. He's asking, he doesn't think that you answered my questions.
Lawyer.
Yes, he doesn't think that you answered my
and the vulnerable. So we have lawyers who act for the poor and vulnerable.
There are really a number of statements coming in. Okay, so somebody is asking why you didn't make such arguments when Charlotte Osei was removed. So there are a number of comments coming through.
That is a different fact, and we can always have another day to listen to the facts. And then Charlotte Osei, as I repeat, is not the Chief Justice. So we can meet. I'm always available.
Please, I want to get your final word in 30 seconds, please.
You know,
I think my final word is that, listen, the process.
In 30 seconds, because we've run out of time.
The process that is being done at 146, let's allow the process. The Chief Justice will have her day before the committee. And do not stampede and now even strap the president that he should do something that is unconstitutional, that he has to do. The DBA, I just want that they've gotten it wrong. DBA, they've gotten it wrong. They don't have the power to arrogate to themselves. And what they have done is these are things they do that people, there's schism, and they should know that the young ones are growing, and the young ones are more old than the older ones. And if they don't take time, the DBA will not have that influence it used to.
Thank you very much, Mr. Dawodu.
They do not have it anymore.
And you speaking, are you not politically affiliated? Okay, so that's a question to, I don't know which of you is to, if you can in 20 seconds really, your final word, and then wrap up.
Now, what are the implications of these actions? I'm remembering that 1st February 1964, when Parliament changed the Constitution of Ghana to a one-party state and President Nkrumah as a life president. I don't want that to happen. The rule of law must prevail. The impartiality, independence of the judiciary, and dignity of our Chief Justice must prevail.
Thank you very much, Madam Gloria Ofori-Boadu. She is lawyer, managing partner, GOB Law Consult. Also, we've had Victor Kojoga Dawodu, private legal practitioner, member of the NDC Legal Committee. I'm sorry, Dr. Nyaho Tamaklo could not join us via video call. I guess there was some connection problem. Thank you very much for joining us today. My name is Beatrice. Join us again next week. Thank you for joining us on Agenda.